The purpose of this podcast is to educate our listeners, and it does not constitute professional advice or services. The legal areas, services, law and process discussed are relevant at the time of recording, and it is important that you seek independent legal advice on such topics to ensure that the law has not changed or been updated in relation to the area of law you need advice on or are interested in.
Court is in session.
Hello and welcome back to episode 2 of Lawyers Who Lunch. I'm Lydia.
And I'm Sophie.
As you know, our podcast is about educating you and informing you about the UK legal system, and we thought it best so that you understand the future episodes and you can easily follow along to discuss who's who in the UK courtroom.
Because if you've ever watched a trial yourself, Suits, or even just a bit of the TV, there are a lot of people standing up, sitting down, wearing the robes, saying things in Latin, and somehow everyone seems to know exactly what they're talking about, and we're not to. But today we thought that we would break down judges, magistrates, barristers, solicitors, clerks, ushers, juries, court staff, who they are, what they do, and how they all fit in together.
By the end of this episode, you should be able to walk into a UK courtroom and at least know who's who, even if you don't know what's going to happen. So let's start with the most powerful person in the room, the judge. In the UK, judges play a central role in ensuring that court proceedings are fair, orderly and conducted according to the law. They control the courtroom by managing how the trial is run, deciding who may speak, keeping questioning appropriate and maintaining professional standards.
Judges rule on points of law, such as whether evidence is admissible and how legislation should be interpreted, and in jury trials, they direct the jury on the relevant legal principles they must apply. And typically, they're usually the person that's sat at the top, above you, looking down on you, in a courtroom.
In criminal cases, if a defendant is convicted, the judges determine the sentence in line with the guidelines issued by the Sentencing Council, taking into account aggravating and mitigating factors. While juries decide guilt in Crown Court trials, judges decide guilt themselves in magistrate courts and in bench trials when there is no jury.
Whereas in civil cases, judges usually determine both liability and remedies, such as awarding damages or granting injunctions, making them key decision makers throughout the legal process in England and Wales. So judges don't actually always decide whether someone's guilty, but they will always decide how the law should be applied.
So, moving on to magistrates. In England and Wales, magistrates often surprise people because, unlike professional judges, they're usually volunteers drawn from the local community rather than legally qualified lawyers.
Before I carry on with that, if you are interested in becoming a magistrate, you are able to register your interest online, and they send you out an email if there are availabilities in the local area, and they focus on criminal or family court. But I would recommend, if you are interested in becoming a magistrate, going online and having a look at doing it. But to carry on, magistrates are actually also known as justices of the peace, and although they are not required to have formal legal training before appointment, they do actually receive structured training and must follow strict guidance when operating.
Magistrates don't sit alone though. They usually sit as a panel of 3 to ensure there's balanced decision making, and they're advised on the law and procedure by a legally qualified court clerk who is also known as a legal advisor.
Again, they are usually sat in like the judge bench bit, so they'll be sat in a row of 3 and the legal clerk sits in front of you here. But again, that depends on how each court is set up. I'm typically going off where we would go. But again, magistrates typically, they deal with less serious criminal matters in the magistrate court, so it might be a minor assault, theft, public order offences and motor offences, and sometimes actually conduct earlier hearings that need to go up to the Crown Court, and as we see on a regular basis, they also sit in the family court and deal with family court cases also.
Proceedings are generally more informal than higher courts, so you're unlikely to see the wigs and the gowns, but magistrates still have significant powers, including imposing fines, community orders and short custodial sentences set within the limits in the law. Next, we'll talk about the jury. In England and Wales, one of the most recognisable features of the criminal justice system is the jury, which sits in the Crown Court.
You're probably all familiar with the jury as well. We all want to be one. I'd love to be on a jury, actually. But a jury is usually made up of 12 members of the public, randomly selected from the electoral register. You can actually opt out of being on the electoral register, but it means you won't get called up for jury duty then. Reflecting the principle that serious criminal cases should be judged by ordinary members of the community, and this goes back to our previous episode of law and everything, of having the right to have a fair trial.
Yeah. Jurors will listen carefully to the evidence presented by both the prosecution and the defence, assess the credibility of the witnesses, and decide the facts of the case. After receiving legal direction from the judge, they deliberate in private and return a verdict of guilty or not guilty.
They don't decide the sentence. That responsibility will rest solely with the judge. Juries are used for the most serious criminal offences tried in the Crown Court, but they do not sit in the Magistrates' Court and are actually rarely involved in civil cases, which are usually also decided just by a judge alone.
Controversially, at the moment, there are talks of removing the jury from the Crown Court completely to progress cases quicker through the courts, because there's currently a backlog of 80,000 cases within the Crown Court.
That's crazy. Well, it's like when we met that lady last year who said that the magistrates had that back. She was a magistrate in Swansea or something like that, wasn't she? And there was a backlog of like 60,000 cases for just like DVLA fines alone. And then, as I mentioned, again, this is a controversial one because not everyone's got an opinion on OnlyFans, but Rebecca Goodwin was raped and her case is not being heard until 2027, despite having solid evidence that she was raped in it. So it goes to show how seriously backlogged the court are.
Yeah, there's just no capacity.
No.
But there's a question of whether removing the jury will help that or not.
Absolutely. That's probably a topic for another session.
So now we'll move on to barristers. In England and Wales, barristers are specialist courtroom advocates who are typically instructed to represent clients in the higher courts, particularly in the Crown Court. They're traditionally the lawyers seen wearing wigs and gowns in court, especially in criminal trials.
Barristers present legal arguments, examine their own witnesses and cross-examine the other side witnesses using their advocacy skills to test evidence and persuade the court or jury.
In criminal cases, there's usually a prosecution barrister, often instructed by the Crown Prosecution Service, representing the state, and a defence barrister representing the accused.
I've noticed we're focusing heavily on criminal law when we're talking about this today, and just generically, but barristers are also used in all areas, yeah, absolutely. Family law, we use them in. They'll be used in civil cases, so they'll probably be potentially used in all that sort of stuff, just to clarify that to our audience that they are used across the board.
Yeah.
But historically, barristers did not deal directly with the clients. Instead, solicitors handled client contact, preparation and paperwork, and then instructed a barrister to appear in the court, which is something we still do actually quite regularly. Is the solicitor is probably the person that does the groundwork, and then we pass it over to a barrister to represent them. That said though, these days, sorry, am I going into yours? Oh, direct access. I am. That's because I'm now trying to... Story.
So, carrying on from what Sophie was saying, while that division is becoming less rigid in modern practice, with some direct access to barristers now possible, the traditional distinction between solicitors and barristers remains a defining feature in the UK legal system.
Okay, let's talk about solicitors now. In England and Wales, solicitors are often the first point of contact for anyone involved and in any legal issue, and we actually play a central role in preparing the case from start to finish.
They advise the clients on their legal position, explain procedures and possible outcomes, gather evidence, take witness statements and handle the necessary paperwork and correspondence.
In criminal cases though, actually the solicitor may attend the police station to advise a suspect and then continue to represent them in the case as the case progresses. They're normally a duty solicitor, I think they're known as. And then traditionally, if the case then proceeds to Crown Court, a solicitor will instruct the barrister to actually conduct the advocacy at trial.
However, solicitors frequently represent clients themselves in the magistrate courts and in many lower hearings. Some solicitors also qualify as solicitor advocates, which allows them to appear in the higher courts also.
Although barristers may be more visible during trials and probably the people you're more likely to see familiar with on the TV because they've got the wigs and the gowns, it's actually the solicitors that are off. I think the distinction needs to be between the solicitors and barristers is that the solicitors are the people that are often doing all the legal work from the start to finish. So what we'll probably be doing is meeting with you from the beginning, doing all the letters to people, emailing people,
doing all the work in the background.
Work in the background and the applications. Whereas I think my module for, and you'll probably learn this when you start to do your SQE, for advocacy was only like that small chunk compared to barristers who actually have to do so many hours in court to actually qualified to become a barrister, because that's what they're trained to do. They're trained to advocate your case in court, and they can go. Don't think it's right that they have to. I think once you're a barrister, you can go up to this many courts, but someone might have to correct me on that. Whereas solicitors are only allowed up into like certain, as I know we've said this already, but you're only allowed up to certain courts before you then have to train to get higher rights of audience.
Yeah.
But again, that's a story for another day when we do court hierarchy.
Yeah. So now we'll talk about the court staff and the people who make it work. In England and Wales, some of the most important courtroom roles are carried out by professionals and the public rarely notices. You don't see them much on TV, but without them, nothing would ever happen.
In the magistrates' court, the court clerk, more actually formerly known as the legal advisor, is a legally qualified advisor who actually advises the magistrates on the matter of law, procedure and sentencing powers, ensuring that their decisions are legally sound, and even in the magistrates decide then the decision themselves, they've been advised on that decision making process by someone who is legally qualified.
And then the usher plays a practical but vital role in all courts, including the Crown Court, by calling cases into the courtroom, organising where parties sit, escorting jurors when necessary, and generally keeping proceedings running smoothly, often described as the courtroom's air traffic control. And
in higher courts especially, official records of proceedings are also created, whether through digital recording systems or professional transcribers who produce authorised transcripts when required. I think you'll probably have seen in like the family court they would like to record it, so it's all just done on the computer.
Yeah. Together, these behind-the-scene roles ensure that hearings are orderly, legally accurate and properly documented, even if they rarely feature in television portrayals of the justice system.
What we're basically saying is the telly doesn't accurately portray what happens in real life.
So now let's talk about the people at the centre of it all.
So we're going to focus on criminal for now, aren't we, I think, from here. First up, the defendant. So this is the person accused of committing the offence.
They'll sit in the dock alongside or near their legal team, and it's really important to remember, just because someone's on trial, it doesn't mean they're guilty. Exactly. One of the most important principles in the justice system is that the defendant is presumed innocent until proven guilty. That means it's not their job to prove they didn't do it, but it's the prosecution's job to prove that they did do it, beyond a reasonable doubt. And depending on the case, the defendant might choose to give evidence themselves, but they don't have to. Right, and this often surprises people. A defendant has the right to remain silent, and the court can't automatically assume guilt just because they choose not to speak. If they do give evidence, though, they can be cross-examined just like any other witness. So now, let's move on to the witnesses, a key part of how courts figure out what actually happened. So witnesses are people who give evidence to help the court understand the facts of the case. So that could be someone who saw the event, it could be someone that heard something important, it could even be an expert, so it could be a doctor or a forensic scientist or something relevant to that case that's going on. Before they speak, they have to take an oath or affirm that they'll tell the truth. And that's serious because actually lying in court is a criminal offence and it's known as perjury. The way questioning works is also really structured. First, the side that calls a witness asks questions, that's called the examination in chief. And then the other side gets to have their turn, and that's cross-examination. So this is where they might challenge the witness's original version of events or test how reliable they were when they were first questioned. Yeah, and sometimes there's even a re-examination afterwards just to clarify anything that came up. So witnesses play a huge role. Their credibility and how convincing they are can really actually influence the outcome of a case. So now let's talk about victims, because their role isn't always what people expect. So you might think a criminal case is between the victim and the defendant, but actually legally this isn't actually the case. In criminal law, the case is brought by the state against the defendant, so it's technically the state versus the defendant, not the victim versus the defendant. And that's because crimes are seen as offences against society as a whole, not just against one individual. That said, victims still play a really important role. They may be called in as witnesses, especially if they were directly affected by the crime. And they can also provide what's called a victim personal statement, explaining how that crime has actually impacted their life. But ultimately, decisions like whether to prosecute, what charges to bring, or whether to continue the case, these are made by prosecution and not the victim. Which can probably sometimes feel really frustrating for the victim, but it's designed to keep the system fair and consistent. So, let's now talk about the criminal courts, the civil courts, because not all courts in the UK deal with criminal cases. That's right. A lot of the court cases are actually civil cases which deal with disputes between individuals or organisations rather than actual crimes. In civil courts, the people involved are a bit different. Instead of a prosecution, you have a claimant, and that's the person who's bringing the case. And on the other side, you've got the defendant, the person or organisation responding to the claim.
You'll still see the judges and the lawyers and the barristers, of course, but the process is actually generally way less formal than what the criminal trials are.
And importantly, there's usually no jury in civil cases in England and Wales. Most decisions are made by a judge alone.
The standard of proof is different too, because actually, instead of beyond a reasonable doubt, civil cases are decided on the balance of probabilities.
So basically, the court is asking what's more likely to have happened.
And unlike criminal courts, the aim isn't to punish someone.
Exactly, it's about resolving disputes. This might mean awarding compensation, enforcing a contract, or settling disagreements over things like property or negligence.
So while criminal courts actually focus on the guilt and the punishment, civil courts are actually about putting things right. So, next time that you see a courtroom on the telly and you follow along with our episodes, you'll know who is in who and who's in charge and who is doing what. Judges run the court, juries decide the facts, lawyers argue, staff keep everything moving, and while it might look formal and intimidating, it's all designed around fairness and structure, even if it still feels a bit theatrical.
That's the wigs for you. Thanks for listening.